Yes, sir, we're live right now.
Yes.
Yeah, I'm just going to start. So, firstly, I'd like to welcome whoever's tuning in right now. This is part of a weekly series of talks on why impunity reigns. If you have been following Mr. B.T. Venkatesh, you might have seen his previous talks under the Floyding India banner, which is a Reach Lawyer and Listening Post event. The basic idea is, of course, to address issues of marginalization, to address why the system has failed those who need the system the most. And today's conversation is the first part in a series of conversations that we've planned in the coming weeks to basically address systemic impunity, to address why our base institutions, whether it's the police and other institutions, have consistently failed us, and to possibly investigate and understand why this continues to be a trend that only seems to be worsening. So today we're joined by Mr. B.T. Venkatesh, of course, who probably needs very little introduction after decades of service as an activist and an advocate for those who the state and most usually don't want to represent. Mr. B.T. Venkatesh has worked with the LGBTQI community. He's worked with trade unions and worked with those whose fundamental rights, particularly with regard to the freedom of speech and expression, have constantly been sort of challenged by the state. Thank you for joining us for this talk, sir. I look forward to hear your perspective on why impunity reigns and particularly your perspective as a former public prosecutor to inquire into some of these reasons. We're also joined today by Professor Kunal Ambasta, who is currently an assistant professor of law at NLSIU Bangalore, among a host of things which I don't think we could adequately cover during this talk. He also teaches and writes about the criminal justice system, particularly with regard to the investigative processes, the way our various components of the criminal justice system work, and about situations in which the criminal justice system has abdicated its responsibility. So, thank you for joining us today here, sir, and we hope to sort of just listen to your thoughts and perspectives as well on what you think creates this atmosphere that's conducive to impunity. So with that, I think I'll just let Mr. P.T. Venkatesh sort of take it from here.
Thank you. Thank you, sir. Impunity. Impunity is a thing which we have been living with for decades. Almost anyone and everyone knows what exactly impunity is. One of the most visible part of impunity which we come across is the impunity of the police. So we see that on everyday situation, if you're going on your bike, if you don't have the driving license, or if you are speeding, or if you are under the influence of alcohol, any of the things, whether you have a license, whether you have a fitness certificate, whether you have drive the insurance certificate, any of these kind of things, the way the police talk to you, the way they seize the license, the way they talk in abusive tone, or the way they seize the vehicle, you feel that, I think that should be the way they should have. You feel that. Somewhere that feel that because that he is a police, he's able to do these things and get away. And we have seen that if you were to be poor, somebody who is in stigmatized communities like LGBT, they use one of the worst kind of language, abusive language, which is that you feel that, where they get this kind of authority from, where they get this power from to abuse. Or that if you have to have a complaint to lodge in the police station, if you want to go there and you sit there for hours on end and no one listens to it, then Saab aayega. The inspector would come, you have to wait. So you have to wait for long hours of time, 3 hours, 4 hours, sometimes into a day, goes in just registering your complaint. The registering the complaint or taking the complaint itself is also a discretion which they employ. That many of these things you feel that you become extremely powerless before the police and see that they do the way the manmani karte hain, the kind of thing they can do that kind of a thing because they have the law supports them. I think this is some feeling where we feel that there is this power which the police have, and that power they use it whenever they want it, the way they want it. and how they want to do it. It's just their choice. So it's one of the most visible part of the impunity we get to see. The second part we see is that the kind of violence we come across, the abuse is one part. We get to hear in the news of a custodial death here, or an encounter there, or that somebody shot in the leg. We know that the kind of story is certainly not the way these two police have told the story. For example, I was referring to in my last occasion that a boy in Ongole was found without wearing a mask, and the police arrested him and beat him up, and there was a custodial death. And the police came with a story. Now, when he was being brought to police station for not wearing a mask, he jumped out of the vehicle and he died of injuries to it. So whether we have, none of us believe this particular kind of story, but somewhere we feel that police must have beaten him and must have succumbed to death. We have this case of Jairaj and Phoenix, which was the case recently in Tamil Nadu. We also see that this is the kind of offenses. So we get to see these violence and custodial deaths, abuses. These are visible kind of a situation which we see that there is this police have acted with impunity. Impunity therefore becomes something which is known to us. All of us have grown with it. Whether it is a small incident of this nature, or whether our own mistakes, small mistakes, errors which we commit, or that what we hear in the media and the way the encounters that happen, we read about that. For example, you had this recent case of a rape and murder case in Hyderabad, where the accused were just shot. That many of us celebrated it. Many of us burst crackers on it. Many celebrities just said, okay, what a wonderful quick justice it happened. Was it justice? How these were all very poor driver and cleaner of vehicle. How could the story of police, which is a tired, oft repeated story of police, that they try to snatch the weapon away from the police and try to shoot the police, therefore we shot him dead. How could that happen? So we know, most of us are aware that this would not be the story. But we know that the police have acted with impunity. The police have just shot them, killed them. But most of us, though knowing it, we are silent about it. Where this comes from is an aspect which we are trying to discuss in this particular series. This series will also be supported by Professor Kunal Ambasta. Professor Kunal Ambasta is one of the well-known human rights activists, apart from being a academic, and he has been known for his support for these kind of cases for protection of victims of human rights violation. Has been for years, has been working on that, and that's something which I am also very happy that he is part of this particular program today. So this impunity which we see is something which has been seen that, okay, what happens then? This is that where this power comes from. So we see that impunity is constructed in manner this way, that the power of the impunity is that someone who commits a violation, who commits a gross violation of law, on the authority which he has, the power which he has, he abuses the same and uses it. And then he is going to be not punished for this violation. For example, this custodial death takes place. He is not going to be immediately arrested. First, there will be no proper investigation of that particular offense. Two, there will be hardly any indictment that happens for the kind of offense that he has committed. Three, there will be no further prosecutions regarding the same. In fact, I had given in last occasion a simple statistic which said that in 2015 or 2016, in that year, 5,340 plus cases were registered as against police personnel for violation, abuse, assault, extortion, threatening, intimidation, maiming, you name any of these kind of things which were accused of, they were accused of it. Out of which hardly few came for a report, and report was submitted, a charge sheet was submitted, And at the end of the day, in that particular area, only one case it was went on for trial, and no one was convicted of the offense. No one was convicted of the offense. Was it that there was no evidence at all as against them? So it goes to show that as I was telling you, that the investigation, indictment, and prosecution are all not done in the manner which is supposed to be. Now, the second thing which we'll also look into is that where this impunity comes from is that the police function under the powers are governed under the Code of Criminal Procedure. The investigation, the way they function, how they arrest, all those aspects are empowered in the Code of Criminal Procedure. Professor Kunal Ambasta, as an expert on that particular aspect, will be in a position to explain it to us. The police are also empowered under the various other statutes. Now that we have these more statutes like the National Investigation Agency Act, many of these acts also give that kind of additional power to the police. That these powers which are there are used by the police, and there is this protection. Act in good faith. There is something which is there in the, for example, if somebody shoots in the course of an incident, an altercation happens, there is something called act in good faith. If somebody has acted in good faith, resulting in some injury, resulting in something, he is protected. So he cannot be prosecuted for that. And if at all you want some prosecution regarding the same, you have to seek sanction. For example, in case of corruption, you have this Prevention of Corruption Act, which mandates that in Section 19 that there is a requirement that if you are initiating proceedings against a government official for corruption, there is a requirement of a sanction. So there is this protection which gives to these officials, which makes them, insulates them from prosecutions and indictment and the kind of investigations for the offenses and violations that they committed. That's something which is the common phenomena we see. I think that gives them the power. While there may be instances of acts in good faith, by and large, we have seen great number of cases where this is the prevalence of impunity and acts of impunity in with the police department is the most visible one for the common person is concerned. But also impunity is not just one. It has two senses which you look at it. One is that impunity as failure of the system to prosecute somebody who commits violation of human rights, or protection to someone who commits the violation of human rights. This is the construct with where this particular thing, impunity, comes from. The other construct is a much broader concept called, the accountability, or that the impediments that are created, that you cannot even prosecute a person for the kind of acts of impunity which is there. It becomes such a painful, long process to do that. So when we see this kind of thing, that impunity becomes we are live with that kind of impunity, and we see this impunity happen, and we feel that we shrug ourselves and say that, okay, it may be a very simple act. Impunity is not necessarily associated only with the police. For example, when you talk in terms of the general construct of corruption, which we talk most of the time, it's also an act in impunity. Perchance, if you bribe an official who does not work and get the things done, and if you were to lodge a complaint against him, you need to have a sanction, prior sanction to prosecute him. So when you have these kind of aspects which go into it, he is insulated, he is protected. Law degree protects him. What exactly is that kind of law that protects him? Why this kind of law protects him? Is that in the garb of protecting some good act in good faith, that many of the persons who have committed acts in bad faith and misappropriated funds, cases of unjust enrichment that made easy money, took tons of bribe. We see these cases, but hardly any prosecution, any convictions that happens in this particular case. Rare occasions we see convictions happen. And by and large, we also have this issue which we come across, that when it makes news now, the prosecution takes such amount of time, 2-3 years, end up we have forgotten about it. And it will be some small news in the 6th page in the newspaper, or certainly it may not be even in the visual media. Visual media looks only at the now happening kind of a news. In the printed news, will be some small column in some corner. We see that the person was found not guilty and acquitted. So this is something which is a thing which we see. We always believe that, it's a futile exercise to prosecute someone who commits a crime, because the department comes and support, and two, the courts don't take action against the offending officials. So there is some kind of a process, mostly because the court also looks at it from the evidence that is led in. Because the police is going to be investigated by police, under police, the investigative report certainly has so many chinks in it. It's very easy for the defense counsel to dislodge the story of the prosecution, wherein the accused gets an acquittal. The victims' failure to get justice is also a consequence of this particular impunity. So therefore, when you look at impunity from this construct, I feel is the an issue which we need to deliberate on, an issue we should think and discuss on. I think that makes greater sense that we start there with this particular series which we are talking in terms of is relatable to see what exactly, why this kind of impunity reigns, that we have no answers to give, whether it's nationally. It's not only the story of India. It's not only the story of police department. It's the story of almost all the countries which we have. Great number of countries, including the developed part, some of the countries in the developed part of the world, face this kind of challenge regarding impunity is concerned. In fact, the recent case of George Floyd and the protest that led into brought into this kind of changes in the kind of protection that were given to the police for prosecution have been reduced because of the same. There have been cases where they said there is some requirement of bringing in a degree of accountability. So when I say that the impunity is looked because of this kind of situations from a narrow perspective of sanction to that of a larger perspective of accountability as it is concerned. I think that's something which is, I'm opening it for discussion today so that we can have an interesting debate on this particular subject and try to see the various aspects. And we also will be taking questions on this. I think I request Professor Kunal Ambasta to take this and just to give his views regarding the same. Professor Kunal Ambasta, I'm sure, I think is quite known. He has done his master's from University of California, Berkeley, and he's presently the assistant professor in National Law School of India and one of the finest premier institutions. He's known for his work. He's alumnus of the same institution, and he's known for his support kind of human rights cases which has done, and his publications in respect of various aspects of his review on the literature on the death penalty is concerned, as a sizable amount of work on the abolition of death penalty. In fact, a number of cases which has not been reported part of his profile, which you don't get it because he has been in this death penalty movement, which is there. He has been fighting cases and supporting cases for the abolition of death penalty all the way for last more than a decade. He has been fighting for these particular cases of abolition of death penalty is concerned. He is a authoritative source regarding that particular aspect as well is concerned. I think he is one of the persons who has reviewed Rajmohan Gandhi's book on abolition of death penalty. He's done amazing work, and today he is with us, and it's such a joy. And he also happens to be a good friend of mine, and such a joy to have him today in this particular thing. And he would give his insight into this particular aspect, so that in the coming weeks we'll be discussing with the various anthropologists, sociologists, and everybody also going to join this particular process. A senior journalists who are going to be part of this process. So we will be kickstarting this particular program, the introductory kind of a program. And today, the aspects which we talk in terms of the kind of experience which Professor Ambasta brings in, I think would give us a better light. So I request Professor Ambasta to start his presentation.
Thank you, sir, and good evening to whoever has joined us. First of all, let me tell you that Venkatesh sir has been extremely kind in his introduction that he has given to me, and he has presented my qualities in a much greater manner than what they actually exist as. So he has been extremely kind, and he himself is an experienced lawyer and a great human rights activist, and he himself has decades of experience. And it is a testimony, I suppose, to his humility that he introduces someone like me in such a kind manner in on a public forum. So I am very thankful, sir, but also I must say that it is your introduction that you have given to me speaks more of your humility than it speaks to me and my qualities. So with that, let me come to this evening's discussion, and thank you for having me also to share my thoughts on this subject. And I must express my appreciation as well for you to have conceptualized this series and to have taken it forward. And without too much ado, I don't want to take too much time because I'm sure the audience might have some questions also. So let me build on what Mr. B.T. Venkatesh sir has also stated in his introduction and conceptualization of the topic today. So we are looking at impunity, and first off, let me also say that I do not possess the knowledge of a political scientist who might be able to give a theoretical background to an understanding of impunity or concepts such as power, accountability, etc., etc. I will speak from my very limited experience and from my very limited knowledge as to how I view impunity. In terms of how Mr. Venkatesh has also conceptualized it, I see impunity in two ways, and I want to present that very quickly before we open up for discussion. One is that I see impunity as a failure of a concept of rule of law. Right? Now, when we look at this idea of rule of law in legal theory as well as in legal systems, right, if it has to be crystallized to, let's say, a sentence, one can say that everything must occur according to legal process, or that whoever you might be, however high you might be, the law is actually a system that is above you. So irrespective of who you are in society or in the system, it is in fact the legal system that governs everything. I think that impunity of official action or of officers, whether we are talking about a police officer who misuses or abuses their power and authority, or we are talking about government which exceeds the mandate of its powers and interferes with other branches, let's say the judiciary, etc., etc. Whether we talk about impunity that exists in practice, in terms of the examples that Mr. Venkatesh sir was also giving you, or we talk about impunity as a structural issue, that our laws themselves have built in impunity within them. We can see that there is some kind of a failure of rule of law, that the law at those particular points fails, or it is designed in a particular manner so as to ensure that certain basic principles are violated. These can be principles of equality, these can be principles of liberty, etc., etc. So I would say that when a police officer exceeds their duty and, let's say, tortures someone in custody, and we fail in a sense to fix accountability for that action, we see a failure of rule of law. And there, the second point that I want to make is that any analysis of impunity that might exist has to also take into account how we function as society. And I want to connect it to the first point to say this, that rule of law is a practice that does not suddenly appear in a legal system. Just because you have a constitution which talks about Article 14, 15, 17, 21, etc., and you have a constitution that is based, let's say, on a separation of powers, does not mean that we start inculcating the habit of rule of law. And in fact, Dr. Ambedkar, Baba Sahib said this in the Constituent Assembly debates as well. And he said that the moment the Constitution comes into force, we in India are going to enter into a life of contradictions. That you have a document that talks about rule of law, that talks about equality, and you have a society that is unjust, that is structurally unequal, etc., etc. Right? Now, impunity stems from there. Impunity is a social culture that exists in Indian society. The practice of caste and caste abuse is something that is impunity at a social level. And it often translates to impunity at a legal level. When you see that the law is not the same in its practice for people who are marginalized, like, let's say, LGBTQ persons or Dalits or religious minorities, what you're seeing playing out is the society's inequality affecting and polluting how the law should work, right? So impunity is something that flows from how we look at these people in society as well. If you do not consider Dalits to be equal, and the police officer comes from a society which does not consider Dalits to be equal, in his day-to-day work, he is not going to follow Article 14 and 15. He is going to follow what it is that he has learned over social habit. And therefore, I would say that the structure or the culture of rule of law is something that is learned, right? And again, to go back to what Baba Saheb Ambedkar said, he said this as well, right? He said democracy is, or let's say rule of law, is a kind of a top dressing on an Indian soil which is undemocratic, which does not believe in rule of law. So a lot of the problems of impunity that we face are also uh, in a sense a reflection of what kind of society exists, and that is why we also believe and tolerate such kind of impunity as well. Lastly, I would say that I also think of impunity as a lack of accountability, right? The fact that certain actors can be assured that the system will not just fail, but fail in a predictable manner, that you can ensure. So a police officer knows that if he conducts an encounter, right, half of society is going to applaud him, and nobody cares really as to what is the purpose of a trial and why a trial should take place, etc., etc. So there is something that a police officer can predict, that there will be no accountability that will be fixed for this, right? There might be some inquiry that might be conducted, etc., etc., but by and large there seems to be this kind of an assurance that impunity will be respected, which in fact bolsters or strengthens this culture of or habit of impunity, or to do things with impunity, right? And I would say that that's something that we need to think about. So I think of impunity in the legal sense as as an effect of the social culture of impunity that exists in our society, which has polluted the kind of rule of law structure that we have sought to build. So we have been unable to build a structure of law or a structure of society where we function in accordance with rule of law. And we see an abuse of rule of law as a result. And that abuse of rule of law becomes structural and it results in impunity. That's how I would see it. And if you look at America, it's the same problem. Their society is still racist, and it is still divided on the basis of the color of your skin or your ethnicity. That social culture is what you see permeating their legal culture in how their police works or how their judiciary and prison systems work, right? Which is what you're seeing an effect of, that black people are shot dead or are killed so often and so callously by law enforcement agencies in the United States. It's an acting out of a social impunity in the legal sense, right? And that's what you see in India as well. So that's how I would view the topic of impunity. I don't want to take too much time because I understand that there must be questions that people might have. So, and I would also like to hear what Venkatesh sir also has to say as to this. So I will conclude there, and if required, I'll come back in again before 7. So, sir, I'm handing it back to you.
Yeah, in fact, I would like to see that how we look from this particular construct. I'm going to ask you some questions, Professor Ambasta, that you see, the people see this kind of a situation. They see that in the courts, they see that the cases of serious cases of corruption which happens, the person is prosecuted, very high officials are prosecuted, and there is this person who has committed a small act of bribery, wherein there are people who face years of litigation, who go to court day in and day out and face consequences and even face convictions, ignominy in the department. So many of these things face. Let me give one example. The people see that the persons who have that kind of influence and wealth, the cases which go against him, the state is handling the case with kid gloves in prosecution is concerned. The whole prosecution is acted in kid gloves. what exactly is that nature of impunity which you would like to throw light upon in such situations? The impunity is not just the violation. The impunity also look at the way the system is used by the authorities are concerned, whether it is more particularly in the question of prosecution is concerned. We get to see, for example, recently we see this in the movies too. We had these two movies of Joy Lilby. In both the cases, we come across the judge telling us that, I'm sitting here waiting for the evidence to come, and that does not come to me. So I see that the person has committed crime. I know that he has committed the crime. I see that the people or victims are there, but I see that I can't do justice because there is no written evidence that is which I can prosecute him to see that punish him in this particular aspect. Now, this bringing this evidence, bringing forth this kind of information is also vested with the authorities concerned. Now, their failure also towards this particular impunity. How do you view this situation? I will see we need to, I'm looking at degree of extrapolating the construct of impunity from that of plain simple violence to that kind of an act of this nature. Just would like to have your views on the same.
That's an interesting way in which you put it, sir. My response to it would be on the lines of saying that when we look at these instances of inefficiency in courts, let's say, or in fact in prisons where people are kept under trial in custody for years on end, etc., etc., and people are unable to access the services that are meant for them. So a lot of people, as you would know, sir, are entitled for bail, but they cannot do not have the resources to furnish bail or furnish the surety or even hire a lawyer, and therefore as a result they keep languishing. So there are several instances that one can draw. If one has to talk about it at a systemic level, sir, I'll say that this is this is a kind of structural inequality that we tolerate because we understand that the decision makers understand that this is a structural inequality that will never touch them. They will never be in custody for the want of a lawyer. Their cases will not be there, which are the ones that keep getting delayed. And again, you see, we don't we are willing to tolerate these violations for people who we consider to be unequal, either in terms of socioeconomic class or caste or religion, etc., etc. So to put it again on a structural level, I would say that these this is a kind of impunity that exists within the structures that we have created, where a judge does not have to care about how many years the person languishes in prison and can keep remanding that person back into custody time and time again, does not have to really bother about looking at whether custodial violence is occurring or not, etc. These are the structures by which impunity is actually put into effect judicially. That you see, there is no effect, no accountability for what is happening here. And this is the grossest and starkest example of a violation or a failure of rule of law, where your law itself has structurally become so inaccessible. It has become so arcane and so unequal that it is resulting in more and more violations and no accountability for those violations at all. So I would say that this is an example where you can see structural impunity coming into the various machinations of the law itself.
I would like to add one more aspects to this. I would like to have your also thought on this. See, recently there have been this. We had this Delhi riots case in the month of January, end of January, where thousands, lakhs were impacted. People number were killed. It was actually a pogrom, one say, violence, one say, and there have been prosecutions now, and the people have been summoned. There have been some of the persons have been accused. In fact, now it is saying that some of the persons who were victims are also being prosecuted. Some of the persons who are protesting against CAA were also being prosecuted. And some of the persons who actually gave very vituperative speeches are not being prosecuted, or that the police are handling them with the kid glove. In the sense that against some, There are prosecuting them for serious offenses of unlawful activities and sedition against the state and many of these offenses. And as against some, they're just making some accusation that they were causing some disturbance. And there's been some deliberate kind of an act regarding the way the people are handled in one case. The other aspect is that we also see in the court system that the state does not does not take the same equal status when it comes down to one Devinder Singh who was caught carrying a terrorist. He gets a statutory bail for not filing a charge sheet. But whereas in respect of number of thousands of others across the country, including those people who've been politically involved, for example, in Bhima Koregaon case, or whether it is Delhi case or in Assam, many of these parts of the country whom we see these cases where the state pursues to such a degree that even a person who is ill, infirm, and who is tested positive is one not given kind of proper medication. For example, you come across to see in the newspapers that any film actor who gets arrested in some case or a politician gets who arrested in some case, the moment he is arrested, immediately he develops a kind of a chest pain and he's taken to a hospital and he is there tested for next 4, 5, 6 days until the bail application is heard in the court. We all know that. We see this kind of a thing in the thing. How this thing is done is that there is a degree of looking away in the system when somebody commits such kind of a thing, or that there is no serious questioning that how it happens. For example, judiciaries need to question this particular aspect. Today, these days, these questions are also not being brought to the courts, some of because there's some feeling that, even if you were to go to court, I don't think what would be the end of the day. In fact, we have seen this kind of feeling among the people that it does not make any sense anyway, kind of a thing. How do you respond to this kind of thing? When we see these kind of cases that happen, the kind of prosecutions that happen, there is this disparity in the whole construct of these prosecutions are concerned. What one level, this one. In fact, we had these cases where in tribal areas, more particularly in India, that a person is arrested and sent behind bars and for months and virtually a matter which you could be walking out of the bail on the second day. He is in prison for months on end and does not happen. So the police also make serious cases. For example, the cases where the activists are arrested. For example, in many of these project-related offenses in Odisha or Chhattisgarh, Jharkhand, where these mining cases do happen, where these activists are arrested on some accusation and then they are sent behind bars and the police pursue the case and they will be denied of bail for months on end. So the systemic failure to a degree that, we allow something of this nature happen, we don't ask these questions, is also adding up to this impunity is one feeling which is the people have. What exactly is the way the system, why this particular situation comes to such a situation, why it comes to such a situation that these things happen. In fact, when you look at it, plain and simple is that as is very Orwellian in its nature, all are equal, some are more equal than the others. Kind of.
Yeah.
I'd like you to provide sense to have that.
Yeah. Yeah, you're absolutely right, sir. I think our any system, any legal system is based on, and for it to properly work, is based on certain assumptions. One of the assumptions is what is stated as a guarantee in our Article 14 and Article 15, which is to say that the law is the same for everyone, and everyone is entitled to the equal protection of laws. Now, that is, I say, it's a fundamental right, but it's also an assumption based on which our legal system works, that the state will not discriminate between people on certain grounds. And I think what we are seeing, so you gave the example of what has happened in Delhi post the riots, or with regard to the arrests of anti-CAA protesters or arrests of tribal activists or RTI activists, etc. What you see essentially is the determination of the state to not follow this kind of mandate of being a disinterested enforcer of law. it becomes something else. It transforms itself to a person, to an organization which has some kind of an agenda to fulfill, and therefore starts targeting people it identifies as its enemies. Now, that is again, in the biggest possible way, a violation of a fundamental guarantee based on which your legal system is supposed to work. So if you, as you said, all animals are equal, but some animals are more equal than others, and it's something that the state is effectively doing. And what it does essentially is that it subverts certain fundamental guarantees. For example, the criminal prosecution process or the trial process is based on the fact that you will have an individual who will stand against the might of the state in court. Right? So the state, which has the machinery of the police, investigation, prisons, etc., is prosecuting an individual. No matter how powerful that individual might be, he cannot stand up to the resources of the state, which is why you have certain guarantees and procedural rights which are guaranteed to the defense. One of these being something like bail, that you will not incarcerate pending any decision, pending conviction, you cannot incarcerate in a manner as to punish. Now, what we are seeing essentially is a subversion of all of these rights and a subversion of all of these guarantees that a legal system has. And perhaps the judiciary also is not standing up as it is supposed to stand up to enforce these rights as well. Just we are currently watching a drama play out with regard to the detention of a particular leader called Saifuddin Soz in Kashmir. And you have an example where the state is saying that he is not under detention, and the submission is being placed on record, and the habeas corpus is being dismissed. And you have media clippings and video clippings where he is saying that he cannot leave his house. So what we might be seeing essentially is that these guarantees, which are supposed to be enforced in a particular manner, we are not seeing a similar enforcement. This, to my mind, is a systemic or a structural kind of a problem. It is not the problem of an instance. Today it's someone, tomorrow it might be someone else, and yesterday it might have been someone else completely. But it's a structural problem of how we have failed to internalize things like rule of law, how we have failed to internalize these rights of liberty, of equality, etc., which makes their abuse so easy by anyone who wants to abuse them. Right? And a lot the thing is this, that a lot of times we as civil society members, as lawyers, also fail in our duty to counter this. So for example, the fact that we accept a separate system of laws for certain crimes and a separate system of laws for other crimes itself shows that we ourselves have probably not internalized the values of equality and due process and procedural rights also. And all of this gives impunity to the state. The state can now happily incarcerate someone and charge them under the UAPA under the guise of something. They can cook up anything. All it takes is an allegation for the UAPA to be invoked, and the result is that somebody does not get bail for years, as we are seeing in the Bhima Koregaon case, that you don't know what the evidence is, the trial is not starting, you don't know what will happen ultimately. But what is essentially happening is that bail is being repeatedly denied to people who are so old and who have been suffering an incarceration for 2 years now, all on the grounds of the fact that there are some terrorist allegations against them, etc. And I think I am not trying to prejudge the case. I'm not saying they are innocent or guilty or whatever. I am saying you have a right to bail that general law guarantees you. It is a right that is essentially linked to Article 21. And what we are seeing is a subversion of this right, with impunity, because no guarantees now matter anymore. The moment UAPA is invoked, everything is off the table. All bets are off. So it's something that you see. So what I'm trying to say is that we have such a structurally biased system that is incompatible with an understanding of rule of law. And it's so easy to subvert rule of law by just invoking a special statute or by just invoking a special circumstance. That in this case, this is the thriving scenario in which impunity can exist. It's the best case scenario for impunity to exist. So the police can do anything, the state can do anything, and there is no scrutiny, there is no guarantee, there is no question. So that's what we have done. And this situation did not start 5 years ago or 7 years ago. It started a long time ago. So the NSA is not a new statute, it's a very old statute. The first anti terror statute that came was the TADA, not the UAPA. We have crossed this Rubicon time and time again, never learned our lessons. So we are seeing the result.
I want to ask one question. See, I tell you, when we say talk all these things, we say this, where this impunity originates. What exactly is this kind of source of this particular impunity, where it comes from, why it becomes so strong over a period of time that we see that more and more acts of impunity are getting strengthened. What exactly, where this source comes from, where this originates, that's something which matters to me.
I would say it originates from a situation where uh, you want to rule over certain classes, and so you want a reflection, and you want the continuance of that unequal social order. That's the root cause of trying to bring in impunity and unfairness into a legal order as well. That's where I would say. So you're um, uh, and I'm not the first person to say this. A lot of people have talked about how certain laws are meant to keep certain sections of society down and to repress certain sections of society. And I think that that's the genesis, and that's the antithesis of things like equality, rule of law, right to liberty, fairness, etc. So it's a desire to bring in that social inequality into legal inequality that leads to us trying to create impunity for such actions, is what I would say. The connection may not be that direct, but I think that's the root cause of why we tolerate and why we encourage such practices to also happen.
Now, one aspect which I would like to also talk to you on this is that, there is this argument which is made that you see that there are hardly any convictions happening in the system. So the accused are getting away from the crimes. Most of the offenses go unpunished. So there is necessity for strengthening the framework which are required. The law which we have is Code of Criminal Procedure, Indian Penal Code, Code of Criminal Procedure particularly, is so ancient, and it's 1973, but actually by and large it is a code that is copied from 1898. That's the situation. And also 1872, the kind of evidence act that we have are not also going to be helpful, and therefore resulting in a situation where the people are getting acquitted. Therefore, there is no convictions happening. So there is a requirement to strengthen this process. So therefore, the people need to be punished who have committed crime. That should be the purpose of the whole system. That's being lost. This is being the cry of the judicial system. This is the cry of the police department, cry of the people that, people are going unpunished. Now, when you see these kind of things, there are two arguments. One set said that requirement of stringency to law that need to be brought into. Another set which say that, the kind of liberties are being taken away. Now, when we have this impunity, which is also overarching kind of situation, which utilizes the older system, and also utilizes the strengthens the kind of pursues regarding strengthening the more stringent kind of situation where, for example, you have the provisions in NA Act which say that the evidence admissions made before the police, everything becomes admissible as against an accused is concerned, which is totally against the whole criminal jurisprudence system. How is this going to affect the kind of acts of impunity as against the state? And that's one of the aspects which I would like also to discuss on.
Sure, sir. Sure, sir. I want to address this question actually, and it's a very important point that you have raised, sir. Also, because this is an often recurring conversation in criminal law circles, and also any discussion of criminal law in India sooner or later comes down to this kind of question about conviction rates and about delay. These are the two things that are usually talked about. So I want to talk about conviction rates particularly, and I want to begin with asking the audience to consider, and I want them to actually think as to why there is this kind of understanding that a low conviction rate is unfair. I don't understand where this assumption comes from, where we automatically believe that a conviction rate which is low might mean that the system is bad. Now, conviction rate by itself does not tell you anything about how the criminal justice system might be working. In fact, there might be a lot of criminal justice systems where conviction rates are very high, but you would probably not want to be in those criminal justice systems. Let me give you an example. China, which is currently considered public enemy number one in this country, has a great conviction rate, right? A very high conviction rate. But would you want to be in a system and accused in a system such as China, where, let's say, any version that the police might put in front of the court is just accepted without scrutiny? So this needs to be decoupled. This talking about a conviction rate and talking about fairness needs to be decoupled. Now, coming to what happens because of a low conviction, right? So let's say convictions are low in India. That means a lot of cases are reaching the acquittal. So a crime is happening, but ultimately nobody is convicted for it, and this is where our problem stems from. Most people think that somebody got murdered, somebody must have done the murder, and therefore, if you're acquitting someone, that means that you have not been able to find out who did the murder, and that murderer is still roaming free. And that is true. And that is an actual valid concern. And I agree that with that. However, the solution to that cannot be that whoever the police puts as the accused is the murderer. When we insist on a high conviction rate, essentially we are saying that somebody has to be convicted. I don't care who is convicted. All these requirements of standard of proof and burden of proof on the prosecution, they are not meant, these rights are not meant to ensure that actually guilty people go scot free and that they are acquitted. Actually, they are meant to ensure that the police do their job properly, right? That's what they are meant to ensure. That if the police does a proper investigation, if the police does collects evidence correctly, does not do something that's illegal, then you will get a conviction. That's what the rule is supposed to work like. We imagine the rule to mean that if the police has said somebody has committed a crime, that crime has been committed by that person. And I think that's where we lose the plot. And because we don't have, we our constant fixation is with hiking the rate of conviction. What our normal discussion also becomes in parliament or on the streets is किसी भी तरह से तुम conviction rate ऊपर करो. Do anything but get the conviction rate up. Right? And if you do that, you are allowing the police to get away with anything. Right? The same way you are allowing them to get away with encounters now, because probably they would have not ended in a conviction, so you just go kill them, right? It's the same thing that you're doing now. In fact, procedural violations become more and more rampant the more and more powers you give to the police. Irregularity becomes more rampant under the UAPA than it is under the IPC. So I would say that you need to decouple this talk about conviction rates and this talk about the criminal justice system. Right? The criminal justice system has several other values. It cannot be fixated about conviction rates only. On Since you raised the question about special laws, sir, and about the antiquity of IPC, CRPC, etc., very quickly, without taking too much time, I would say this: that even today, terrorists who are accused, right, in court are charged with the IPC along with the special statutes. So along with the special statutes, you will also charge a terror accused with waging war against the government of India 121A, conspiracy to wage war against the government of India, etc., etc. Right. And those are offenses that fully cover any terrorist offense also that might have been committed by this person. So the question then becomes as to why you need that special statute at all, like the UAPA Tata quota. And as you have correctly identified, sir, in your question itself, you need them for to carry out procedural violations. And this is something that I've talked about and written about also in newspapers and elsewhere as well. And I believe that special statutes are only needed because you want to violate rights. There is no other reason and no other rationale for having special statutes at all. A terrorist offense can also be a murder, can also be a general offense. There is no need to say, oh, this is a special offense and therefore I need a special law, etc., etc. Unless you want to violate rights, which is exactly what you want to do with impunity. And NIA Act, etc., etc. These are the things that give you impunity to violate rights.
So two arguments are placed on such situation. One argument is that these acts, these offenses which are there, are not fully covered under the Indian Penal Code. For example, you talk in terms of the kind of acts of attack that happened, whether it's Bombay, whether it is blast cases, many of these things. These were not envisaged the time when the Indian Penal Code was made. So therefore, the very ghastly offences were heinous offences where innocent civilians are killed, and therefore there is a need for a law which is stronger. That's required is one argument that is placed. The second argument that is placed is that, what about the justice to these victims who have been done? So therefore, the perpetrator who commits such heinous crime need to be treated with a strong way. It's not the way it said that the handling him with the existing system is like handling with him kid gloves. So you can't handle him with the kid gloves. So therefore, the stringency of the law becomes justified in this particular process. For example, you see this 2008 case of Bombay, wherein that the law was overnight changed. The Unlawful Activities Prevention Act was overnight changed to make it more and more stringent. And it was 2018, it was now brought even to that of an individual kind of situation. So when we see this kind of changes, it is being done because victims need to be protected. Justice to the victim is something which is done. Now, the question is that if we were to say that these are all not necessary, we can be done in the same old law, and you have shown that the same old law does not functions in the same way which is supposed to be. It is so lenient regarding the processes are concerned, resulting in possible acquittal. Even in fact, that old law were to be used, somebody argues that Najmal Kasi would have been acquitted for the offense. Would have been acquitted of the offense because there's hardly any evidence as him being there. So that kind of thing would be said. Therefore, because there is a need that some degree of stringency of law being brought into. For example, you have the case of Nirbhaya, where we try to make more and more stringency regarding the sexual offenses are concerned. So when we have many of these statutes where you have brought in amendments, only to ensure that some degree of justice to victim is concerned. So when we look from that construct, how can we say that it's also an act of, it leads to an act of impunity? Maybe that there is a way that is being abused is one part. But is it not that we do have this kind of need for such kind of a statute in first place, or the protection of this particular given situation, given the kind of violation that we have seen, which is very different from those envisaged under the Indian Penal Code when it was acted upon. It's an 1835 Act, which acted and came into force in 1860.
Yes.
How come that in 2018, 2020? How can that be useful in such situation? Therefore, we have these kind of changes. It's only towards justice to victim. How can we demand that the laws are sufficient in these cases also? That's something which is a question which people do keep asking. There's a need.
Definitely. No, sir, I completely get what you're saying. And this is an argument that is often made. And in fact, it's an argument that is made without question by the government also. A very peculiar thing to notice is that a lot of these terror statutes are passed at moments of national crisis, when support for any government measure that looks very tough on paper is at its highest. Even the opposition will not oppose such a statute immediately after a terror attack. So, as you said, when the UAPA was amended after the Bombay attack, it was a moment of tremendous national unity where everyone said, yes, we need a special law. And everyone agreed that, and it was in fact the UPA government which had hated the POTA and which had actually repealed the POTA, which brought in the UAPA amendment, right? So a lot of times it's very peculiar to observe that this happens at a time after a terror attack, right? And there's a reason for that also. And this is the time where this logic is accepted without question, that terror is a different class of offense. Terror needs a special statute, and therefore please don't stop the government from creating a special statute that deals with terror appropriately. I want everyone who's watching this to take a step back, and I want them to think for themselves, other than these arguments that have been made, as to why is terror different? Why have we accepted this logic that a terrorist attack or a terrorist offense is something that is qualitatively different? Right? So, and why is a terrorist murdering someone not a murder? It is also a murder. In terms of punishment, IPC 302 gives the highest punishment that is known to law, which is execution. No TADA, no POTA, and no UAPA can exceed that punishment. If you look at 121A, waging war against the government of India, it's the death penalty or life imprisonment. So, in terms of substantive punishment, we are not changing anything. I understand there might be certain things that you need to outlaw organizations, etc., etc., consider certain organizations to be terrorist organizations, all of those things. Why can that not be done under the IPC? Why don't you amend the IPC? Let's say IPC talks about unlawful organizations and unlawful activities, etc., etc. Now, to my mind, and I might be completely wrong, I'm not saying that everything that I'm saying it must be completely accepted. To my mind, the real difference to my mind, you don't really have a substantive difference between a terror offense and an IPC offense. In fact, the IPC was framed in such a manner so as to cover all classes of offenses. And just because it might be old may not mean specifically that it is inadequate. So, for example, if one looks, and this is just coming to my mind, if one looks at the illustration to Section 6 of the Indian Evidence Act, 1872, it is a typical terror attack that is being talked about. So he says that, let's say a person is being prosecuted for waging war against the government of India, and offenses are committed in which government servants are attacked, government offices are attacked, government jails are broken open, right? Etc. etc. Now, these could be terror attacks. Why would they not be covered as terror attacks, right? So, in a sense, I don't see a substantive difference. My understanding is different. I say this. I say that what you want to do essentially is that you want to do two things. You want to tell the public that you're treating this offense seriously, because a lot of these terror attacks call into question the government directly, right? And you would remember the kind of hangama that happened after the Bombay attacks took place. The home minister of the country resigned, etc., etc. So you need to show that we are tough. We are not taking this lying down. When Parliament was attacked, we mobilized our armed forces on the border, etc., etc. So at a lot of times, these special laws become political tools. Right? And secondly, I would say what these special laws allow you to do is that they change the procedure that is applicable. Now, nobody is saying that a terrorist should not be punished. Please understand that I'm not advocating that terrorists should be allowed to roam free and should be allowed to attack and kill people. I am saying that a terrorist should be tried, and they should be tried fairly as you try everyone else. But what these special laws allow you to do is that they change the procedure in such a manner that it becomes impossible or very difficult to defend someone when you accuse them of a terror charge. So if you, let's say, do away with the right to bail, then an accused person already gets imprisoned for 7 years before there is any progress in the trial. And after 20 years, they get acquitted. What's the point of an acquittal such as that? So I would say that the real reason why we enact statutes such as this is to violate procedure, as to violate rights, and to create an impunity. The moment you want to punish someone, you just have to invoke a statute like this. Who did you think it would? You thought it would be invoked against someone like Kasab. Did you think that it would be invoked against professors of Delhi University and other universities across the country? But that's what it does. Once you give this power to the state, then you can't control it. Then it will get abused. And by then it's too late to sit and oppose all of this. So one has to question the basic rationale. That's what one has to do. Anyway, I'll stop there. I realize that I've spoken too much. I've spoken a lot. So
Actually, it's needed, this kind of debate. In fact, what we are looking at today is that this debate need to be taken to the people. In fact, one of the main issues of this concept is that when we talk in terms of Floyding, so you saw the difference, when the protest that happened regarding Black Lives Matter, the kind of protest that has been going on even in US now, and some of the protection that were given to the police and being made, police being more and more accountable, was the procedure that has been followed by the government now. Now, I understand that it's also a similar situation which, when the governments are in crisis, when we see that they're in difficult situation, they would come with the change. I think the same argument would also be applicable to these situations as well. But there is a requirement that there should be a better equipped argument regarding how are we to address, to see that rights and liberties of the people are protected, one of the major things. Second, that the act of impunity need to be reduced, so that there should be no necessity for, in fact, one of the major arguments which we come across, in fact, Manisha Sethi, who in a recent article, she said that we still consider police as a force, not as a service. Why should police be called police force? Why you can't call it police service? So our mindset itself is still stuck in a colonial construct which says that police are here to enforce law. Police are here to compel people to follow law. So there is some degree of force that is associated with the very concept of police. Post 70, she comes with an argument, post 70 years of independence, 70 years of the Republic, why are you still talking in terms of a force? Why can't you talk in terms of a service? Why don't we look at it from a position of enabling agency to ensure that rule of law is maintained? I think that's an argument which we need to talk again. It's also subject for the another day. I feel one of the most important thing today was that we wanted to open up this particular kind of discussion so that we can bring in much thought to it in the coming weeks. We request your participation, Professor Kunal, in the coming weeks. We are going to talk on this. We are going to get now journalists who are also going to participating in it, and academics and number of activists who are working on these issues, rights. I think whether it's women's activists or child rights activists or the tribal rights activists or workers, many of them are facing this kind of situations when it comes to see that absence of protection for the people. I think from that note, I would like to end today's
Thank you.
And we request you to be here again with us on the next week with the other guests who will be joining us in participation. I think with this, we will end today's session. Immense
thank you
for giving your very insightful opinion on the subject, which is really going to be very mad, because that's going to set the ball rolling regarding the discussion on the subject is concerned. Thank you very much.
Thank you for having me. Thank you for having me.
Mr. Saurabh. Mr. Saurabh.
I'd firstly like to take just the opportunity to thank both of you. I think the discussion you all have had today, particularly from of course, the law standpoint, but the reasons for why these laws seem to fail, and the various kinds of impunity that we just sort of encounter on an everyday basis. I think that's been a particularly illuminating discussion. I can see as a law student myself that often what we study, particularly in terms of constitutional guarantees, is not the way we see laws play out, particularly special laws, as has sort of come up in discussion today. So I just like to thank you all for sort of just engaging in this discussion today. And as introductions go, I think this was a fairly exhaustive one to why impunity reigns, truly in that sense. I'd also like to
Thanks.
just say to those who sort of joined us today to please follow us on our YouTube channel, Reach Lawyer, which is the collective that sort of runs this Floyding India series and discussions like why impunity reigns, has a YouTube channel. So please follow us on YouTube. You can also check Mr. BT Venkatesh's Facebook page itself. We regularly post events there. We post various discussions that we sort of scheduled for the coming weeks as well. And you can follow us on Twitter as well if you're on Twitter. And with that, I think I'd just like to sort of end today's discussion. It's been extremely illuminating, and I hope this carries on in similar fashion in the future as well. So thank you.
Thank you.